In this video, I'm going to discuss the numerous administrative agencies that exist to assist an employee who's having trouble in the workplace, whether it's retaliation, race discrimination, whistleblowing, failure to accommodate, non-payment of wages, unsafe workplace practices, environmental hazards. There's a government agency for almost any possible thing that's happening to you at work. The key is knowing who to go to, whether or not it's required to go to them, and whether or not you should be consulting with an attorney along the way.
Could you first give an overview of all the main government agencies that protect employees in California and what each one does?
There are several major protectors of employee rights in California, and one of the biggest one everybody knows, it's the Labor Commissioner. So if you have something going on at work, you're not being paid correctly, you're not getting given breaks, you've been retaliated against, one way you can address those issues is to go to the Labor Commissioner's office and file a complaint. This is known as an administrative proceeding. There won't be any jury. It's fairly transactional. It's a perfect place to go for a small dispute. Maybe you were supposed to be reimbursed some expenses that weren't reimbursed. You don't want to file a whole big lawsuit over it. The Labor Commissioner serves as almost like a small claims court for employment disputes. Next to the Labor Commissioner's office, there's also the Unemployment Office. The Unemployment Office is one of the very important offices for somebody who's been wrongfully terminated, because there you can go to bring up the fact that your employment has ended and that you're entitled to some wage replacement under the unemployment benefit statutes. Also, there's the Department of Fair Employment and Housing. The Department of Fair Employment and Housing is the governmental agency that is responsible for ensuring workplace fairness in California's employment places. This would include covering things like race discrimination, religious accommodation, disability accommodation, retaliation, harassment, sexual harassment. There's just a very wide area of fair employment laws that are administered by the Department of Fair Employment and Housing. Important to note that you must file a claim, what's called a charge of discrimination, with the California Department of Fair Employment and Housing before you can bring a lawsuit. If your case involves violation of federal laws, then there is a federal equivalent to our state Department of Fair Employment and Housing. This is the more popularly known Equal Employment Opportunity Commission, the EEOC. Both the EEOC and DFEH, Department of Fair Employment and Housing, have rules that require a charge of discrimination to be filed within a certain amount of time of the wrongful conduct. By visiting the website for the EEOC or DFEH, you can learn more about how soon your complaint must be filed with those agencies. No matter what, do not wait to research how much time you have to bring your complaint to these agencies. If you forget or fail to bring your complaint to the state or federal equivalent for fair employment claims, you may be barred from bringing those claims under the applicable statutes. In addition to these agencies I've described, there are numerous agencies that address the concept of workplace safety. Cal-OSHA is the agency that is responsible for ensuring that employers meet their statutory duty to provide safe workplace for employees. So, if you work at a place that's making you breathe in harmful chemicals and you know it's not safe, one of the options you have is to report that behavior to Cal-OSHA.
If an employee is still employed, should they contact a lawyer to file a claim at one of these agencies, or should they do it on their own?
There is certainly nothing wrong with an employee filing a claim on his or her behalf with a government agency. You do not need to consult with a lawyer before filing a complaint with a government agency. In many respects, it's completely unnecessary, because you don't want to say that the only reason you filed the complaint with the agency is because the lawyer told you to, because then it makes it seem like you don't care about the issue you complained about. So if you know something unsafe is happening to consumers or to yourself at the workplace, then go ahead and make a complaint to the responsible agency. For instance, If you work at an auto parts store and they're dumping oil illegally back behind the shop, then you would make your report to Cal OSHA, you can make your report to Cal EPA, you can make your report to the federal OSHA, you can make your report to the federal EPA, you can make a report to all of those places. There's nothing wrong with making your report to every applicable agency that you think should or would want to know about the conduct.
If an employee just got fired, should they go to the agency first or should they call a lawyer?
There's no rule about whether an employee should contact a lawyer or an agency first before the other. The only reality is use your common sense. If you're not sure about what to report to the agency, then maybe it makes sense to consult with a lawyer beforehand. However, if you know exactly what to report to the agency, why wait to get an appointment with an attorney? Go ahead and make the report. Just remember, these reports will be evidence in your case later. So be truthful, be concise, and try not to be hyperbolic and saying inflammatory things in your complaint. Just keep it factual.
If an employee is still employed and they submit a complaint with one of these agencies, is their employer going to find out and will they get retaliated against?
One of the most important aspects of making a report to a government agency is to not do it anonymously. Do not make anonymous reports to government agencies, because if you do, it allows your employer to retaliate against you and claim that they didn't know it was you. Let's say that you work for a painting company and you are complaining that they're frequently dumping paint into the sewers that lead to the waterways. You know it's illegal. You're the only one who's complained about it. If you go to Cal EPA and you make your complaint and do it anonymously, Cal EPA is only going to tell your employer that somebody complained about illegal dumping of paint. They won't say that it was you. Now the employer, of course, is going to know it was you because you were the only one who ever complained about it. They're going to fire you in retaliation for making that complaint. And then in court, they're going to claim they never knew it was you because the complaint was anonymous. They had no idea it was you, and so therefore, they didn't fire you in retaliation. It's very important to not be secretive. Yes, it's true. If you report your employer to a government entity for illegal conduct, it's highly likely that you will be subjected to retaliation. However, you will not be protecting yourself to make that complaint in secret, because the employer is going to find out through the rumor mill anyway, and even if they're wrong, they'll get rid of 2 or 3 people they suspect to be the whistleblower just to ensure that the whistleblower is gone from the work environment, and then they'll hide behind the anonymity of the report to the agency. So, when making workplace complaints, always be above board, be open in your communication, copy those who need to know about it. If somebody's dumping paint illegally, chances are your supervisor needs to know, your supervisor's supervisor needs to know, the president of the company needs to know, their compliance director needs to know, their human resources person needs to know. Tell everybody who needs to know and make sure that they know you're the whistleblower.
Should employees first go to HR before they go to a government agency to try to fix the problem first?
The best practice, if you're at a point of experiencing something that you're considering reporting to a government agency, your best practice is to report it to the government agency and your employer at the same time. In fact, let your employer know of the conduct by virtue of your complaint to the government agency. Give them a copy of the screenshot that you submitted to the government agency outlining the details of the wrongful conduct. Under some circumstances, government agencies are the best place for cases because the government can actually prosecute cases on behalf of people. This fits really well for employees who have smaller claims where the employer might be a national employer. That's a great fit for the Department of Fair Employment and Housing to try and work with these big employers to settle smaller claims.